300 litigation documents, 4 years of deal records, board minutes, correspondence, expert reports, wire transfers, and internal communications. A commercial fraud allegation worth $4.2 million. A client conference tomorrow. The problem isn't the volume. The problem is turning a document pile into a reliable working picture of the matter, one you can actually use to advise a client and run a case. There is a version of this where you ask Claude to summarize everything and get back 3,000 words that are impressive and insufficient. And there is a version where you work through the file with Claude as a structured thinking partner and end up with something you'd actually use. This episode is the second version. The matter is Westbrook versus Ellery. Westbrook Capital Partners is a private equity fund. Marcus Ellery was their investment advisor for 4 years. Westbrook alleges he diverted $4.2 million in fees and commissions through undisclosed arrangements with counterparties on deals he was recommending to them. Ellery says the arrangements were disclosed. The case turns on what was known, by whom, and when. The document set is 300 documents. Core investment agreements, 22 deal engagement letters, 48 board minutes across 4 years, counterparty communications across 11 transactions, advisor internal emails obtained in discovery, wire transfer records, a forensic accounting expert report, the advisor's own expert report, regulatory correspondence. The wrong starting prompt is, Claude, I'm attaching 300 documents from a commercial litigation matter. Please read them and give me a summary of the case. What comes back is 3,000 words. The basic facts, the parties, the disputes, a general sense of what happened. It sounds comprehensive. And it is, in the same way a map with no scale is comprehensive. It states propositions without anchoring them to specific documents. It synthesizes contradictions into a coherent narrative. It presents allegations in the same register as established facts. And it ends. The lawyer has 3,000 words and still doesn't know what to do on Monday. Before any analysis, 2 things have to happen first. The matter frame. Before Claude gets any documents, it gets context. The parties, the forum and procedural stage, the pleaded claims and defenses, the known disputes, the purpose of this review. This is not optional. Without the matter frame, Claude has no basis for assessing what any document means in context. Significance cannot be assessed intelligently without it. Then the document map. Categorize all 300 documents. Document type, date, author, participants, apparent subject. Do not ask Claude to assess evidentiary significance yet. The map's only job at this stage is to make the file visible. And then clusters. Core agreements, deal-level correspondence by transaction, board records, financial records, advisor internal communications, expert material, regulatory material. 300 documents become 7 working groups. At this point, the lawyer hasn't asked Claude to analyze anything. The file is visible. That's a different starting position from having 3,000 words of summary. The lawyer can see what they have and what's missing before they start interpreting anything. The next step is building the matter's working picture. A people map, who appears in which documents and in what role. An event map, the sequence of deals and decisions across the 4-year period. And a chronology with date discipline, every date classified as stated, derived, approximate, or unknown. Claude does not manufacture precision where the material doesn't support it. While building the people map, a specific question gets asked. Which entities appear in the counterparty communications that do not appear in any document disclosed to the Westbrook board? Claude returns with the following. Ellery Capital Solutions LLC appears in counterparty communications on 7 of the 11 transactions reviewed. It appears in deal engagement letters held by counterparties. It appears in wire transfer records as a recipient entity. It does not appear in any board minute. It does not appear in any quarterly investor report. It does not appear in any document that was disclosed to Westbrook in the materials reviewed. Claude does not say this is fraud. It does not say Ellery Capital Solutions LLC is connected to Marcus Ellery personally. It does not determine whether the non-disclosure was intentional or material. It surfaces the pattern. It flags the absence. The lawyer determines the significance. The next actions are now specific. Who is Ellery Capital Solutions LLC? What is its corporate relationship to Marcus Ellery? Was it ever disclosed to Westbrook in any form not captured in these 300 documents? Was it disclosed verbally at a board meeting and not recorded? These are investigation tasks. Claude didn't manufacture them. It found them in the documents. With the people map and chronology built, the next work is finding where the documents conflict and where the picture has gaps. 2 engagement letters. Deal 4 engagement letter, filed with the Westbrook board, uses language referring to customary market fees. Deal 7 engagement letter, held by the counterparty, not in the board file, uses specific percentage language describing a fee arrangement with Ellery Capital Solutions LLC. The instruction to Claude is specific. Document A uses language that could be read as disclosure of fee arrangements. Document B describes what appears to be a specific arrangement using different language. Identify the difference precisely. Do not produce a synthesized account of the disclosure position. Do not determine whether either document constitutes adequate disclosure. Claude identifies the language difference. It does not resolve the legal question of what constitutes adequate disclosure. That's a lawyer task, and in this case, a legal research task. Which brings us to the unknown register. Every unresolved question becomes a structured entry. What is unknown? Why it matters? What next action could resolve it? Whether the board's general approval in Minute 14 constitutes informed consent to the specific arrangements in Deal 7 is a legal research question, not a document review question. The register separates the two. Unknowns are outputs, not failures. The lawyer who knows what they don't know is in a better position than the lawyer who has a summary that papers over the gaps. 2 final steps before the working brief. The adverse material review. 1 board minute contains language that could be read as a general endorsement of the advisor's fee structures that is potentially adverse to the plaintiff's position. The instruction to Claude is direct. Identify documents in this set that could be adverse to the plaintiff's position. Do not determine whether they are legally adverse. Do not rationalize them against other documents. Surface them for lawyer review. Claude does not rationalize it away. It surfaces it. The lawyer decides what it means. Then prioritization. Based on everything identified, the people map, the contradiction register, the unknown register, the adverse material. What requires attention first? The answer separates into 4 buckets. Immediate lawyer action. Further investigation. Legal research. Can wait. The Ellery Capital Solutions LLC question is immediate. The board Minute 14 consent question is legal research. The wire transfer pattern is further investigation. The 300 documents have become a working plan. This is what the final output looks like. On one side, the summary, 3,000 words, no provenance, allegations presented as facts, contradictions resolved into a smooth narrative, unknown questions not surfaced, adverse material not flagged, no next actions, impressive, insufficient. On the other side, the matter orientation brief, 8 categories, what we know, anchored to specific documents, what is alleged, distinguished from what is established, where the evidence conflicts, with both accounts preserved, what we don't know, with the next action that could resolve each gap, what may be adverse, surfaced, not rationalized, what requires legal research, what requires verification, what I should do next. Same 300 documents, completely different output. This is what I actually wanted from the 300 documents, not a 40-page summary. A working picture of the matter the lawyer can interrogate and act on. If the output from this workflow could be summarized as Claude reads litigation documents faster, the workflow has failed. The measure is what the lawyer can do with the output, whether they can identify what's established and what's alleged, whether they can see where the evidence conflicts, whether the unknowns have been surfaced rather than papered over, whether the adverse material is visible rather than rationalized away, whether they know what to do on Monday. The full litigation document triage workflow, all prompts, the unknown register template, the contradiction register, and the matter orientation brief. will be Workflow 002 in the AI for Lawyers Workflow library on Substack. Link in the description when it's live. There is one more step in this workflow not covered in this episode. After the orientation is built, asking Claude to try to break the picture you've constructed. That's covered in a separate episode. Claude found the problem I wasn't looking for. Also linked in the description. That's the episode. See you in the next one.